The Supreme Court has just issued a notice on a crucial public interest litigation that challenges a long-standing legal provision preventing under-trial prisoners from casting their votes. This PIL seeks to empower thousands of individuals currently held in custody, yet presumed innocent, to exercise their franchise. The petition directly targets Section 62, subsection 5 of the Representation of Peoples Act 1951. This section imposes a blanket ban on voting for anyone who is in prison or the lawful custody of the police, with the sole exception being those in preventive detention. A common argument that keeps coming up is that this provision violates Article 14, that is, right to equality. Petitioners argue it creates an arbitrary distinction between two groups: an unconvicted under-trial stuck in jail, often due to their inability to furnish bail, versus someone facing similar charges but out on bail or parole. The law has historically barred individuals who haven't been convicted, effectively punishing them with the loss of voting rights. This exclusion was notably upheld in the 1997 Supreme Court judgment, Anukul Chandra Pradhan versus Union of India, which cited three main reasons for this restriction: administrative challenges, the idea that a prisoner cannot claim full Article 19 freedoms due to their own conduct, and the need to prevent the criminalization of politics. However, the current PIL argues that this reasoning is weak. An article published in the Constitutional Law and Philosophy blog back in 2020 details a lot of these criticisms of the 1997 ruling, pointing out that the court seemed to contradict itself by using fundamental rights to discuss the ban but then calling the right to vote merely a statutory one. Furthermore, it fails to logically explain why someone out on bail poses less of a threat to electoral probity than an unconvicted under trial. Given that securing bail often depends on wealth, this distinction unfairly targets the economically disadvantaged. By issuing a notice, the Supreme Court is now formally re-examining whether this statutory restriction can withstand scrutiny against fundamental constitutional rights, making this a key moment for electoral and civil rights in India. Follow LiveLaw to stay updated with this issue and more.